Good afternoon. My name is Jerard Ross. I'm one of the medical legal advisors here at the MDU. And I'm joined by Will Griffiths, who's an employment law business partner for Peninsula. Peninsula is an organisation who give employment advice to MDU members who have group care membership. In terms of what we're going to be talking about today, I'm going to talk about challenging consultations, and the title of Will's talk is Misconduct or Misunderstood. So I'm talking about challenging patients, and Will is perhaps talking about challenging staff members. You'll get a certificate of attendance in the next week after completion of everything. And I thought it might be helpful if we started my talk with a series of polls to try and engage your experience in the audience of challenging consultations. So let's launch one of the polls. So you should have an opportunity to answer a question in the boxes of the webinar. So it says, since the onset of the pandemic and its restrictions, our experience of managing challenging consultations has been either it's more common, less common, or roughly about the same. So if you could answer that now, I can see that we've got about half the people here have answered. Give that another few seconds. Okay, we haven't had everybody answer yet. We're about 60% of the audience have answered so far, and about 3/4 of the people have found that challenging consultations are more common. So 77% in fact have found them more common, 4% less common, about 20% about the same. So our experience of this matter is that we are finding doctors and practice staff having to deal with more challenging issues as a result of the pandemic and all the new problems which were added to all the previous problems which were present for doctors and staff having to deal with patients. Let's go on to the second question if we could now. I'm happy that we're able to manage challenging consultations. Thanks for engaging with these polls. It's really helpful that you're able to give us some feedback about your experience in the real world. So that one looks a little bit more closely closer. And interestingly enough, it's much the same. So 52% people thought they're perhaps not happy to manage challenging consultations, but perhaps not unexpectedly, given we've got a very experienced audience today. About half the people, 48%, felt they are able to manage challenging consultations, which is interesting because one of the things that we see quite frequently is that challenging consultations spark off processes in a practice that are quite hard to manage. And my personal experience is I'm not sure that they are always handled well, but equally these are exceedingly difficult things to deal with at times. Let's launch the third and last poll. A robust response to a challenging patient is always appropriate. Just coming in now. I think we're just getting towards the end of it now. Okay, good. So 44% of you felt that was true, and 56% of you thought that was false. It's an interesting question, I think, and as I'm sure I know there are doctors in the audience, and whenever you see an always in an MCQ in an exam, we always used to get slightly concerned about that being true. And I think that a robust response is sometimes appropriate. I'm not sure it's always appropriate, but it will depend on the particular circumstance of what's going on with the patient. Obviously, you have to protect staff and look after your staff. They're an important resource of the practice, but equally, sometimes there can be explanations for the way that patients are interacting with doctors and with their staff. Anyway, thank you for that. So what we're going to try and talk about today is what constitutes a challenging consultation, try and understand the causes, to offer some solutions to consider, to think about the role of external bodies and to think about the GMC. I emphasize this last part of the GMC because one of the difficulties we have as doctors and as practices is that practices are looked at from the outside. They are reviewed, and decisions that are made can be reviewed by other people. So let's think about quickly the features of a good consultation. Well, we would expect a good consultation to be between appropriate interaction with a receptive patient, a doctor who's compassionate and understands what's going on, is knowledgeable. There's a degree of mutual respect between them. There's an ability and a willingness to communicate, and there are adequate resources to allow them to do so. So that's what we would hope to see in a good consultation. We want all our consultations to be good, but of course, we know that that is not the case. And various studies from different countries have shown a prevalence of challenging consultations of between 15 and 30%. And many of you as GPs will be expert in managing that. A difficult doctor-patient relationship questionnaire in a study from 1994 showed that between 10 and 20% of patient encounters were regarded as difficult. And these patients can end up raising multiple complaints or concerns with different agencies, which you as a practice have to try and deal with. There are lots of difficult patient behaviours, and I've listed a few of them here from an article in the Family Practitioner. So, violent and aggressive or verbally abusive patients, unresolved or repeated complaints, something that we see quite a lot of. Multiple concerns being brought to consultations, a sort of shopping list of problems, patients with psychosomatic type illnesses, patients who are never satisfied whatever you do, people with secondary gain, people who are manipulative or lying, people who tell you that everything hurts, people who are uncooperative, patients often with addiction issues or difficult psychiatric problems. These are all examples of issues that can be classified as difficult patient behaviour. But of course, it's not always about just what the patient is. There can be issues to do with you as a doctor. You can feel angry to be being placed in a certain position. You can be tired or fatigued. There are out there dogmatic and even arrogant physicians. I'm sure it's none of you, but I've certainly seen examples of that, both in my clinical practice and to some extent when I'm working in the MDU. There can be situational issues which make interactions very, very difficult. So patients may not understand, there may be language issues, there may be multiple people in the room all asking for information. You may be trying to break bad news, which makes the encounter particularly difficult before you've got anywhere. In terms of patient factors, we've outlined some of those. They may be angry, they may be frightened, they may be resistant to hearing the news, they might be manipulative or somatizing, they may be grieving, and there may be numerous medical concerns, all of which need addressed at some point. So patients can behave in different ways for different reasons, and it can be helpful if we try and work out why they're behaving in that way. Patients may be unwell, and that is an important thing to consider before classifying somebody as a difficult patient or an interaction as difficult. This may be a health issue which is coming to the front. They may have had previously bad experiences. You might be seeing them, for instance, in a room where they have been with a seriously unwell loved one who was also getting bad news. There can be a lack of understanding about what you are able to achieve in the practice, and the fact is that patients aren't using the right channels for addressing their concerns. They may be exasperated because of their unrealistic expectations of what you can achieve. There may be cultural differences, and there may be a genuine fear about what is going on. Of course, also, the problem could be you. Characterizing the psychological characteristics of difficult patients doesn't always solve the issues. There's quite a lot of research indicating that clinician factors are relevant in challenging consultations. Michelle Lim summarized this in the Journal of Ethics and said, both the patient and the physician bring to the medical encounter social and personal characteristics that contribute to defining the nature of the patient-physician relationship. She went on to say that multiple studies emphasize the value of partnership and teamwork in remedying that broken patient-physician relationship, and recommended responding with empathy to the patient's expressed needs and keeping an open mind. A perceived failure to do so making a complaint more likely. Now, that's easy to say, and it can be very difficult, particularly when we take into account some of the things that might be impacting on your ability to deal with a patient. When I say your ability, I know we've focused on doctors' interactions, but equally, some of these things may be applying to practice staff, managers, receptionists who are having to deal with the patients as they come to the front desk. Sometimes patients feel very happy to give non-medical members of the team a harder time than they might give to a GP. So are you, as a member of staff, are you stressed or overwhelmed? Have you got issues at home? Have you eaten? Have you been to the toilet recently? Are you running behind time and exasperated at the requests that are being made? Have you got somewhere else that you need to be? And does this patient sometimes, do you have issues that are beyond your clinical comfort zone? And sometimes, of course, it isn't any of those things. It isn't really to do with you or the patient. It's to do with these increasingly complicated needs that the patients may have and the limitations of the systems in which we work. So let's imagine let's imagine a scenario. We've got an uncooperative patient. That's how they've been classified. It's a middle-aged man who's been coming in with several appointments over the last fortnight, complaining of a recurrent and severe headache. He has a history of alcohol abuse, has fallen frequently, and is rarely compliant with advice. He's becoming increasingly uncooperative during consultations and isn't following your guidance as regards treatment. He's had several consultations about his headaches with permanent staff, and eventually he's seen by a locum GP, who in the end refers him to the MAU at the hospital. And it turns out that the patient has a chronic subdural hematoma. Now, obviously, that is just one scenario, and you could change about the facts of that to encompass a lot of scenarios that we see. But it's not unusual for us to come across patients who've been seen by lots of staff with chronic coughs, for example. They've been passed around lots of individuals that have come back repeatedly with the same issue, and nobody has joined the dots or gone back and looked at the notes and said, actually, we need to take this a step further and investigate whether there could be a medical issue underlying this. So that's an example here. The GMC are very clear. You have to listen to patients, take account of their views, respond honestly. You have to be polite and considerate. You have to treat patients and individuals, respect their dignity and privacy, even if they're not listening to what you say. You still have to treat them fairly and respect whatever their life choices are and what their beliefs are. So when you're handling a challenging patient, you do have to think about whether or not their behavior may be due in part to a medical condition, and if possible, treat that. It's always helpful, as you know, as experts, to get collateral history. It's always appropriate to consider whether an examination or investigations are necessary. And as ever, we would always recommend keeping careful, comprehensive, contemporaneous records that you can rely on. Sometimes, and I've had this in my clinical practice, it's to do with the personality clash. Sometimes the patient would just be more cooperative with a different person. So sometimes it might be helpful to consider identifying somebody in your practice who's good with these challenging patients, although that might be quite a hard chalice to accept from somebody else. It is satisfying, however, to succeed when other people have failed. We've done a survey when we looked at 172 members. Somewhere 94 were GPs and 78 were juniors, and we asked in a 3-week period, how many of them had been involved in violence and aggression. We asked over 3 weeks, should I say. 57% of the members who responded had been physically or verbally assaulted in the 5 years prior to the survey being done, and most of them had not received any training on handling challenging patients and particularly the situation of impending violence. So, what are these signs of impending violence? These will be easy for many of you who've had the appropriate training, but perhaps others are not quite so aware of it. But raising tone, raising volume, increasing restlessness, red in the face, finger pointing, invading personal space, and verbal threats or refusals to communicate. So what do you do when you have that angry patient? So one of the first things is not to assume that you understand why the patient is upset. Allow them to tell you what the problem is. Their behaviour often stems from mounting frustration and a lack of information. For instance, a long wait to see a doctor, compounded by perhaps uncertainty in the diagnosis and a fear of potentially serious condition. So, if possible, reassure the patient you can see they're upset. Allow the patient to vent. You don't need to become emotionally involved. Acknowledge the anger. I can see that you're really angry about this. Validate it. I can understand why you might be angry about this. It's a very frustrating situation that you're in. Offer to explore the situation in appropriate depth, and ideally that should be out of earshot of other patients if that's possible. But bear in mind, you don't want to become physically trapped with an aggressive patient. Equally, you've got to be careful about ensuring that you are not making it worse with the way that you're interacting. So be aware of your own body language, try and keep good eye contact, and move slowly and steadily, no rapid movements. You diffuse aggression by actively listening to what the other person has to say. So you acknowledge and emphasize positive aspects of what is being said. Don't minimize negatives. Show respect through appropriate formalities, sir, madam, addressing them politely. Work towards familiarity. Don't start off by using their first name. Show understanding and empathy, for example, by reflecting, clarifying, and summarizing their thoughts and feelings so that they understand that you know what's concerning them. Try and avoid expressions of power, things like "you must calm down." Kindly explain the aggression to staff is not appropriate if they're being aggressive, and explain that there are other patients in the waiting room if that's where you happen to be, and the safety of patients and staff comes first. Explain to them that you will ask the patient to leave if their behaviour persists, and if necessary, you will call the police or security if threats are made and the patient does not moderate their behaviour. In terms of practical measures, keep away from the patient, don't put yourself in a corner, ask for weapons to be put down, not handed over. So asking them to put a knife down rather than saying, "give me the knife," is more appropriate. If there's a panic button, use it. If things are getting beyond your control, leave the room, and don't feel that you shouldn't be calling the police. So in other words, call the police if it's appropriate. Have a debrief as well after there's an episode of aggression or violence. The fact that it wasn't your fault doesn't mean it can't be learned from. Could anything have been done better in that circumstance? Accept that you're going to be upset though. You may need some time out afterwards, and I think as doctors we're not good at acknowledging that these things have very serious impacts on us as clinicians, and sometimes you may need to take some time out. It's important though that you take steps to protect yourself and others from future violence. You may not be the only person that this person has been violent towards. So if a frightening event takes place, don't just ignore it, don't gloss over it. Report the incident if that's appropriate. Make sure it's discussed and there's a debrief with colleagues. Document the conduct in the patient's notes so that others are aware. I'll come back to what we're going to document in a wee while. Consider pressing charges if that's appropriate, and make sure that senior colleagues are involved. You may want to consider individual care plans or the violent patient scheme for certain patients. Consider also whether there might be a safeguarding concern with this patient. If they're violent to you, could they be violent to other people? And of course, as we said right at the very start, do consider whether there may be an underlying medical condition as well. If you do have to tell the police, keep it factual. You don't need to discuss medical information generally. You would be discussing the fact of their behaviour, and telling the police about a violent patient or an aggressive patient is a very helpful step to take for further management of that patient further down the line. I mentioned the idea of this patient being violent perhaps to other people. Could there be safeguarding? We've alluded to this need to protect patients, but there may be, for instance, children at the home that the person lives in. There may be vulnerable adults in that home as well. Consider whether their behaviour does raise safeguarding concerns about those people as well. It might be worth just talking through your concerns with the practice and with the designated person for safeguarding. In terms of what you're going to document, you're going to document a factual account of what occurred, avoiding judgmental comments about them, but making sure that what you've recorded is clear and factual, perhaps noting down who else was present when this is done. It's appropriate also to make sure you're clear about what information was given to the patient and what information has been disclosed to the police. Eventually, you might get to the stage of ending your professional relationship with the patient, and the GMC have got some very, very clear advice about when that is appropriate. We sometimes see this idea of zero tolerance being brought to the discussion, and of course, violence should not be tolerated. But there is, should I say, some very clear guidance from the GMC on how you should approach ending your professional relationship with the GMC, with a patient, and warning the patient about that, if that's appropriate, is something to consider doing. So the GMC suggests you warn the patient before you end it, that you do what you can to restore a relationship if that's appropriate. I'm not for a second saying that that's appropriate with a violent patient, but in a patient who's perhaps behaving inappropriately with regard to their behaviour, for instance, lots of complaints coming to the practice on the same issues, it's appropriate to point out their behaviour is not acceptable, warn the patient about what you're going to do, that you're considering ending a relationship, and there are things they can do to help restore that relationship, explore alternatives to ending the relationship, and also think about discussing the situation with an experienced colleague or your MDO. That's what we're here for. We often have these sorts of discussions. Sometimes, and violence is an example, immediate removal from a GP list can be justified. The part of the English regulations, which that comes from, is on the screen now, and there are similar regulations in Scotland, in Wales, and in Northern Ireland too. Okay, so one of the things that's helpful to do in that circumstance is to make sure that you have got a crime number from the police and that it has been reported to them. So it's immediate removal may be justified when there's a crime number. When you've gone to MDO for advice, you normally inform NHS England or the Health Board in Scotland or Wales that you intend to remove them in writing. You inform the patient this is going to happen and keep a record in the notes of the reasons for the removal. Unjustified removal is one of the circumstances in which complaints may well be held up. So it's something to be cautious about, making sure you're following the regulations as regards removing. So if removal is not appropriate, it would be appropriate to consider sending a warning letter. And warning letters are things that we are very keen to see in place in those difficult relationships with patients. That the patient has been told that the relationship and their behaviour is inappropriate. They've been told specifically what the problem is, and that's on record before the patient is removed from the list. So in terms of the warning letters, there's really good advice from NHS Protect. Unfortunately, NHS Protect no longer exists, but their guidance is really good. It's still available. If you go looking for guidance on warning letters and other written communications, using NHS Protect as well as another search term, you will find it. It is very good, and the guidance, I think, is still valuable. They talk about ensuring that the name, the role of the sender is there. There's a brief description of the behaviour and the incident, the details of previous steps to address behaviour if they've been taken, why the behaviour is unacceptable and the impact it has, what will happen if it's removed, if it's repeated, i.e. you will be removed, and who will be informed of this. So, thoroughly recommend that piece of guidance. Really helpful if you can get warning letters into the records for patients. So keeping yourself safe, as mentioned above, you're not alone. There are many other bodies who have obligations to reduce risk of violence happening in the first place, but there are steps you can take to keep yourself safe. So beware things like scarves and loose items of clothing which can be used if you're in close proximity to patients. Keep your body language non-aggressive, so you're not trying not to stare at the patient, try not to raise your hands, try not to put yourself into a corner, keep your voice steady, keep a degree of eye contact without being challenging, making sure you're not in a corner and you're not going to be trapped there, and be aware of where your staff are with patients who may be difficult. Keep doors open if that's possible. Make sure there's a help button in the room. So in terms of general points from this, communication, I think, is key. If you think an encounter isn't going well, it probably isn't. If it will take you less time to nip it in the bud, then do that and have to deal with a complaint. But just because a patient feels a certain way and you disagree, it doesn't mean it isn't true for that patient. Be aware also, however, that your circumstances can impact on your ability to communicate and deal with a challenging communication episode. So the fact that you're hungry, that you're angry about something else, that you're late for a meeting, that you're tired and because you've been dealing with lots of other patients, all of these things can impact on your ability to address a challenging patient. Sorry, somebody's just started drilling outside my window. Somebody addressing a challenging patient well. So there will be questions. I'm happy to address them, but what I'd like to do is to go on to Will's talk, if that's okay, and I'll come to your questions at the end. Charlie, do you want to pass over to Will now?
Good afternoon. Thank you, Gerard. Is that come up and can you see my slides?
I can see your slides, Will. That's fine.
Thank you very much. Okay, yes, so hello everybody. Good afternoon. My name's Will Griffiths and I am the lead employment law business partner, and I partner with the MDU. So as you'll know, as part of your MDU membership, you receive free employment law, HR and health and safety advice. And I work within the team who would advise you when you do call. So myself and around 8 other consultants, business partners, would be there to support you when you do call. So just a quick note, just as a side note, that we are only talking about Great British employment legislation today. People, yourself, members in jurisdictions of Northern Ireland, Republic of Ireland, Jersey, Guernsey, Isle of Man, please contact the advice service if you are in those jurisdictions. So my session will last around 30 minutes. As Jerard mentioned, we will be taking questions at the end for questions on his session as well as mine. So if you do have any questions, please do put them in the chat and we will talk through them at the end. So just a quick reminder, when you are calling the employment law service that you get through the MDU, if you at any point you feel it's necessary to have that you've got an issue with staff, or you've just got a general query around holiday calculations or recruitment or resignations or anything like that, please do call us on the number on the screen there. Please quote your group care membership number and also the account number, the authorization code MDU001. When you call through, we will ask you for your account number, which will be the MDU001, and then we will then ask you a little bit later for your group care membership number. So it's important that you do provide us with that when you do call. Okay, so moving on to the content for today then really. As you know, the session is called Misconduct or Misunderstood. So I'll be going over the overview of misconduct within the workplace. We'll be having a quick look at whether something could be deemed as misconduct or perhaps misunderstanding. Has there been a dispute between employees, for example, and they've misunderstood each other? We'll be looking through the importance of what a thorough investigation is and what that looks like, the importance of drafting sound allegations. So if you were going for a disciplinary, what allegations you would put in that invite. And then we'll be looking at an overview of a disciplinary hearing, and we'll go through a quick summary at the end. Okay, so where an allegation of misconduct has been made, we need to make sure we do three things in essence. We need to act promptly. Any delays could give the indication that that behaviour or misconduct is okay. We need to carry out a thorough, fair and impartial investigation to establish if there is a case to answer, or perhaps whether it's just a simple misunderstanding. And then we need to consider whether any formal disciplinary action is appropriate. However, there is one thing to think about when you're looking at misconduct. Is that misconduct so severe that it may need to or warrant a suspension, or perhaps there may be an instant where you're afraid that evidence may be tampered with, as you know that you need to move through an investigation process into misconduct? And is it therefore easier if that employee is moved from the practice in order for you to complete that investigation? If there are no concerns that the misconduct is severe enough to warrant a suspension, then we'll need to look at appointing a trained management representative to conduct an investigation. Where possible, this really needs to be a different person to that person that's going to be involved in that disciplinary proceeding. So one person would need to conduct the impartial investigation. They would then hand that on to a disciplinary chair then to take forward with the disciplinary to decide whether a disciplinary sanction is appropriate. If there are concerns around a real gross or serious misconduct or risk of evidence tampering, then you'll need to consider suspending the employee. This will be with pay. This will be whilst the investigation is carried out. Where the decision is taken to suspend, ask the employee to attend an interview. This is essentially a fact-finding exercise that will help you establish the employee's concerns, what happened, their case, and why it happened, to decide whether there is a case to answer to move forward. That you will also need to make clear that suspension is not disciplinary action. Sometimes suspension can be seen as disciplinary action, and therefore it is we must ensure that suspension is not confirmed as disciplinary action. This is just a process that you need to go through as a practice to ensure that everyone is kept safe during this investigation. But please be mindful that suspension should only be kept as short as practicable. And through that investigation, we need to analyse and consider the evidence and carry out any other fact-finding or interviews with any witnesses and the employee. And we need to gather all our evidence from a variety of sources. Then, once you've completed your investigation, have you then decided whether there is still a case to answer? If not, then perhaps there is no case to answer, or perhaps it warrants more of an informal warning. If that is the case, you must contact the employee as soon as possible once you've decided that the evidence that you've gathered does not warrant a potential gross misconduct sanction, which is a dismissal without notice immediately. If it's the case that you are bringing the employee back to work, you must notify them immediately, and it's always a good idea to follow that up in writing. If it can't be resolved informally, then you'll need to then write to the employee to notify them in writing that they are required to attend a disciplinary hearing. And we'll explore that in more detail in upcoming slides. So, looking at examples of misconduct or potentially whether something is a misunderstanding. We need to differentiate between misconduct and misunderstanding because it's important that we have our allegations and there is a case to answer in order to take an employee through a disciplinary. Misconduct is taking excessive breaks, for example, incorrect patient file keeping, rudeness towards patients or staff. A misunderstanding potentially could be a doctor-patient miscommunication, genuine personality clashes perhaps, and potentially cultural misunderstanding. Examples of gross misconduct would be those that fall in the lines of theft of property perhaps, fraud or dishonest conduct, gross medical negligence, serious sexual or racial harassment, for example, or accessing a patient's medical records without the need or authorization. It's really important to differentiate whether an incident of case is a case of misconduct or amounts to misunderstanding. This is because the way the misunderstanding would be handled differs from the way you would handle a misconduct issue, and in turn, gross misconduct. Misunderstanding can arise when there has been a miscommunication between a doctor and their patient, or indeed between two members of staff. Perhaps, for example, where a patient has complained about a doctor's prescription causing more harm because they use it twice a day rather than once. Cases of genuine personality clashes may also amount to a misunderstanding, where members of staff fail to see eye to eye. For example, perhaps on a non-serious work-related issue. Sometimes people have poor communication, and that's when personality clashes can happen, or some people aren't as collaborative as others, and they work differently. Poor communication skills from the part of medical staff could give rise to misconduct if this leads to miscommunicating a patient's medical needs, for example. In this instance, perhaps failing to record a patient's symptoms correctly, that's a misunderstanding that could lead to the patient not receiving the right care. And in those instances, perhaps misconduct has occurred, and we need to investigate to see whether disciplinary action is necessary. Moving on then to the misunderstanding and how we deal with that. So, if we're dealing with misunderstandings, this can often escalate into arguments within the workplace. Potentially, sometimes they can escalate into fights and physical violence. So it's important that we deal with misunderstandings and disputes within the workplace early on, and ideally through an informal process in order to rectify issues before they escalate. Mediation is a non-evaluative process where a neutral party assists concerned parties towards understanding the other's perspective. Through this, facilitates possible solutions to the situation. Mediation is not so concerned with the legal rules, but with finding a resolution to the situation that the parties can live with. The mediator's job is to help the parties that find that point where a consensus can be reached, but the mediator can be an internal or external party depending on the seriousness. So it's really important that we try, if we need to, address misunderstandings through mediation. Sometimes it might not be necessary and it's just an informal conversation that needs to happen with both parties. However, if things aren't resolving themselves between two employees, then we would need to consider whether mediation is necessary. As mentioned before, if we fail to deal with these issues, they can result in further misconduct, also gossiping and rumours flying around within the practice, and that makes things more heated and escalated before potentially you get a resignation come in that may lead to claims potentially of constructive dismissal. So you can tell here that mediation is a real key mechanism within the workplace in order to try and resolve workplace disputes. So what is the process for mediation? First of all, the parties must agree to mediate, and if so, the following steps then should be taken. We need to agree on the mediator. The mediator should be someone completely independent of the parties, and although there are no requirements in a voluntary process, it is recommended that an experienced qualified mediator from a reputable dispute resolution organisation such as CEDR should be used. It may be of interest to you all that we actually offer a service called our Peninsula face-to-face service, who have trained mediators that at an additional cost can come out to the practice and hold this mediation session for you. They meet with both employees prior to the mediation session and provide you with a report and check in on the employees later on down the line. However, if you would prefer to deal with this in-house, you would need to appoint that independent mediator and ensure that they meet with both employees before and then mediate during the session, and then draw up ideally an action plan and check in how we are moving on with that action plan afterwards. That action plan is called a mediation agreement. Because the process is voluntary, it's essential to have an agreed document that sets out the terms for the mediation. We'd need to agree a time, a date, and a venue for the mediation. It's normal to set aside a day for this mediation. It's desirable, but not essential, that the venue is on neutral territory. So approximately 2 weeks before the mediation, the mediator should contact the parties and explain the process, each party's role within the process, and what is expected of them. At the beginning, before the mediation, both parties should exchange a brief summary of their dispute, setting out the facts, the evidence, and potential legal issues, and the nature of the dispute or grievance, at least 7 days before the mediation. A copy should also be sent to the mediator. Also, it's good practice to include any documents that either party intends to rely on or are relevant to the dispute between them, and these should also be engaged 7 days before the mediation session. So, moving on then to an investigation for misconduct. As part of the disciplinary procedure for misconduct, managers should carry out all necessary investigations to establish the facts. Where appropriate, there can be an investigatory meeting with the employee to gather the evidence, at which point an employee does not have the right, but may be permitted to be accompanied. Those circumstances where someone may be permitted is to see whether you've got a contractual or policy right within your practice's employee handbook or policies and procedures to see whether there is actually that contractual or policy right to be accompanied at an investigatory meeting. However, within the employment law, it is not essential that they don't have that right to be accompanied at an investigation. Remember that employers may suspend a practice on full pay pending completion of investigations if that conduct is serious or grossly enough. Where investigations show that misconduct has or may have occurred, the employee should be informed in writing of the basis of the problem. The information provided to the employee should include any evidence provided by any witnesses and must be sufficient to enable the employee to prepare to answer the case. Every allegation of misconduct should be properly and impartially investigated before the formal disciplinary proceedings are started, in order to establish all the facts relevant to the case. This will be particularly important in cases of alleged or suspected gross misconduct. An investigation may, for example, involve reviewing the employee's personnel record, for example, to check if someone is late lots and how often they are late. You may need to interview other employees or patients or doctors or any other third parties, for example. Any allegations made against an employee will need to be kept confidential and communicated only to those who have a role in the investigation. As part of the investigation, the employee who is accused or suspected of misconduct may also have to be interviewed. The purpose of an investigatory interview will be to establish facts only and not to judge the employee or make any decision about what action to take. It is important that we ensure that no disciplinary action follows directly from an investigation meeting. This could really seriously flaw your process and the warning issued. It is important, therefore, that the person conducting the investigation is not the same manager who conducts the subsequent disciplinary proceeding. This may be difficult in smaller GPs, but where possible, the two stages, investigation and disciplinary, should be separate and handled by different people. As mentioned on my previous slide, if it's impractical or potentially undesirable to management or a GP partner, then the Peninsula face-to-face service also offer a service that they can come in and do the investigation and disciplinary process for you. Please call the advice line if you have any issues or you want to find out more about what they do. Okay, so the importance of a thorough investigation. This was shown in the case of British Home Stores and Birchall. So this case essentially established that before a dismissal is considered for misconduct, the Birchall case sets out why a thorough investigation is necessary, as well as other requirements. It also offers insight into whether a dismissal for misconduct is fair or unfair. So the facts of this case was that there were irregularities identified in staff purchases at the BHS store. To determine who was responsible for the irregularities, BHS took evidence from dockets relating to purchases that staff had made and also took witness statements. This evidence suggested that Birchall was responsible for the irregularities, and she was later dismissed. Miss Birchall argued that BHS had not clearly established her guilt. The case was heard in its employment tribunal, and the case was then appealed to the Employment Appeals Tribunal. The appeal tribunal stated that there was no requirement to carry an investigation at the level required in the criminal court. In criminal law, there is a requirement to prove guilt beyond all reasonable doubt. In civil law, there is a requirement to have reasonable belief in the guilt on the balance of probabilities. The appeal tribunal set out that there were three following steps that are required before dismissing an employee on grounds of misconduct. They said that the employer must genuinely believe that the employee committed the alleged offence. The belief must be based on reasonable grounds after an appropriate investigation. The investigation must be reasonable in all the circumstances. So as you can imagine, it's all very case specific. So it's what investigation is needed in that case. If there's further investigation needed that may lead you to a potential different outcome or different consideration, then you must go and investigate those that evidence to ensure that you have reached all avenues that could for the outcome of the employee. So once you've done your investigation, you would need to invite that employee to a disciplinary hearing. And it's important in that disciplinary hearing that you set out those sound allegations. What is the importance, though, of allegations? Well, they're to ensure that all facts are set out and the employee in question knows what they need to answer for. Employees can defend themselves properly, and if the employee in question is unprepared due to a lack of sound allegations, the hearing may actually need to be postponed and you may need to start again. If a decision is made to dismiss the employee who was not given the opportunity to defend their case properly, this could potentially give rise to unfair dismissal claims. So, when inviting a person for suspected misconduct to a hearing, it's not only important to set out the time and date of the hearing, but also the allegations they must answer for. For example, where misconduct concerns lateness, the allegations should be laid out to the employee in full. For example, you have been late on the following days for this length of time, etc., etc., so that the employee is able to answer them and give a good response at the hearing, and they know which days and which times they are accountable for. Another example may be where a wrong injection perhaps has been given to a patient. So in allegations, we'd need to lay out when this was, who the patient was, and the name of the wrong injection and the name of the injection that should have been administered. In all, the better the allegations that are outlined, the better the employee will be able to defend themselves. If employees don't understand the allegations levelled at them, they can't prepare accordingly, and this could cause the warning to be overturned or even a dismissal held to be unfair. So, the overview of a disciplinary hearing. Disciplinary hearings should be held without unreasonable delay. Reasonable notice should be given, and the right to be accompanied should also be given, setting out the complaint against the employee, as we've just discussed. The decision must be given to the employee in writing, and any decision to dismiss should be taken by a manager who has the authority to do so. The employee should, without unreasonable delay, be invited to a disciplinary hearing after being given reasonable notice and told that the hearing is to be held under the employer's disciplinary procedure. The employee must be granted the right to be accompanied and by the hearing by a work colleague or trade union representative of his or her choice. The employee should be given a full opportunity to answer the allegations and explain his or her conduct, challenge the witness statements, and ask questions and present evidence if he or she wishes to do so. They may wish to call relevant witnesses to support his or her case. The employee should, after the hearing, be informed in writing of the outcome. However, don't be afraid to pause the outcome of the disciplinary if you feel that further investigation is warranted. And in those situations, it's good to write to the employee that the outcome has been placed on hold pending further investigation. Okay, so in summary, consider if the case is a misconduct issue or misunderstanding, and then take appropriate action through potentially mediation or disciplinary. Misunderstandings can be resolved through mediation, but remember, with misconduct, a proper disciplinary procedure should be followed with a full investigation held by an impartial and different person to the disciplinary chair. Remember that all allegations should be set out to employees in question and in as much detail as possible. Thank you very much for your time today, and I'd like to welcome any questions.
Will, I've got one about the service that you offer. Can you explain what support you offer directly to practices if they do have to discipline a member of staff?
Absolutely, Jerard, not a problem. So as an NDU member, you can call the advice line, as I mentioned on slide 3, I think it was, that and you will speak to either myself or one of the team. We're all lovely, very knowledgeable, and we'll be able to support you through any contact cases that you may have. The service that I mentioned around face-to-face, whilst we can support you and give you advice and help you perhaps draft questions or letters for anything that you have with employees, we do have that face-to-face service that can just completely take it off your hands if you wish to do so. But with that, that does come with an additional cost.
Okay, and the turnaround time for them raising a concern with you and you getting back to them with some advice?
So if you call us straight away, we'll be able to advise you on the phone straight away. That shouldn't be a problem. If you email into us, we tend to respond to emails within 3 hours. And if you call us and we're not available and you'd like to speak to me over and over again, for example, and I'm not available, then I would call you back within the hour. And if I'm not able to do so, we'd advise you then at that point if it may be a delay.
There's a couple of questions that I thought I might put to you if that's okay.
Not a problem.
Let me make sure they're still coming in. Somebody's asked if you could just repeat the guidance regarding legal representation disciplinary. Can you just go over that again?
Yes, so an employee has a legal right to be accompanied at a disciplinary, not necessarily at an investigatory meeting. So an investigatory meeting is informal unless you have the contractual right within your policies and procedures that they all should be accompanied at a hearing, at an investigation meeting. However, the law puts an additional burden on the employer to ensure that they have the right to be accompanied at a disciplinary hearing. They can't waive that. So if the employee wants to bring someone, they can do so, and they can bring either a fellow employee or a trade union representative.
Okay. Another question here. In fact, they're still coming in. Give me a little spin down at that one. Why do you have to pay somebody full pay when they're suspended if it's their fault they're suspended?
Ultimately, through an investigation, you haven't determined guilt yet. Yeah. So when you can't put an employee at a detriment for suspending them, and therefore that's why full pay is warranted, because then we would breach the contract of them being paid for action that you have taken on the employee. Okay,
somebody's asked a question, I think, to do with complaint about warnings to patients, which was how long should a warning last for? So I think that's for me, Will. But warnings last for 12 months, or should have been issued in 12 months prior to a patient being removed for the same behaviour. Again, that's the same across the different jurisdictions in the UK. I think that's us at time. That's us at 2 o'clock. I think we've addressed the majority of the questions that have come in. Sorry we haven't been able to get to everything, but thank you very much, Will, for joining us and talking us through an important and a really quite difficult and challenging issue for practices. And thank you very much for listening to my talk as well. If you have any specific questions, do come back to us at the MDU. We're here to do our best to help you. And as a member, you can ask us for assistance on anything that you are struggling with, and we'd be delighted to review that. Will, thank you again.
Thank you very much. Bye-bye.
Bye-bye.